Hi, my name is Katherine Brennan, and today I'll be talking about liability and disaster. According to Merriam-Webster, the definition of liability is a state of being responsible for something. All three levels of government, the federal, state, and local levels, have some sort of legal responsibility that may result in liability. When referring to liability from an emergency management standpoint, we are most likely talking about vicarious liability, which is the legal doctrine that assigns liability for an injury to a person who did not cause the injury, but who has particular legal relationship to the person who did act negligently. Managerial responsibilities are placed on emergency managers who must comply with the government ethics rules and special requirements. Some of these responsibilities include planning and training and following proper protocol and procedures. The National Federation of Paralegal Associations, also known as NEFPA, and post 9/11 federal law have created new standards that apply to all emergency managers. The 9/11 Commission stated that the compliance with the standard should define the standard of care owed by a company to its employers and to the public for legal purposes. NEFPA established a shared set of norms for disaster management, emergency management, and business continuity programs. It also recognizes ways to exercise plans and make available a listing of resource organizations within these respective fields. Negligence is common law doctrine that has evolved over the years. Its basic principle is this: every person has a general obligation to act in a reasonable manner at all times considering the circumstances. When one acts or fails to act unreasonably, and that act causes injury to a person or property, liability ensues. There are four elements of negligence: duty, breach of duty, legal causation, and personal injury or property damage. When all these things coincide with one another, the result is liability. Units of government also enjoy some degree of immunity, or protection from legal liability, for many of their activities. Disaster response statutes and common law provide customary defenses and immunities for protection of emergency responders who are working in the capacity of a government employee. In the emergency management context, negligence usually arises from the failure to perform specific governmental duties. The unit of government may incur liability from failure to properly train or supervise emergency management workers. Activities that may cause negligence liability include failure to adhere to a plan, executive-level decision-making, or incident commander's lack of wisdom. Another frequent cause of liability is failure to comply with a legal duty, such as OSHA law pertaining to health and safety. A violation of law may be used as proof in civil suit requesting damages for personal injury or wrongful death. To pull all this together, I'm now going to discuss the 2010 BP oil spill, which addressed the issue of liability. On April 20th, 2010, in the Gulf of Mexico, the BP-operated Macondo project blew up, claiming the lives of 11 people and releasing 5 million barrels of oil into the ocean over the course of 87 days. It is the largest accidental marine oil spill in history, and the disaster affected everything from the environment to health to the economy. On May 18, 2010, BP was designated the lead responsible party under the Oil Pollution Act of 1990. This meant that BP had the operational authority in coordinating the response. Criminally, BP was found guilty in court on 11 counts of manslaughter, 2 misdemeanors, and a felony. This punishment caused a $4.5 billion fine. They also put strict operating guidelines and restrictions and a temporary ban from new contracts with the United States government. However, the charges didn't stop there, as they were tried in civil court. This increased fines to $42.2 billion. BP was accused of 9 faults, including not using a diagnosed tool to test the strength of cement, ignoring a pressure test that had failed, and not plugging the pipe with cement. Federal claims offices were set up along the Gulf of Mexico to ensure all damages were assessed and proper financial retribution was disbursed. There were many learned lessons and proposed changes following this disaster. One of the most important proposed changes was to do away with the statute in the 1990 Oil Pollution Act that puts a $75 million cap on the responsible party before the government intervenes financially. Such a small amount of financial responsibility does not match with the billions of dollars of damage that oil rigs are capable of. Liability continues to be an important part of emergency management as the government is put in charge of our health and safety. Issues with liability and disaster can be seen today as shown with the case study on the BP oil spill. This concludes my project on liability and disaster.